time, I'm going to introduce our next guest, who's a personal friend, and she's a wonderful defender of liberty. She and her family have been engaged in a 37-year-old battle. I think I told you a little bit about it last night. We're always talking about the legal fees, and when I talk about the legal fees, you need to understand that I'm talking about what it costs them when the government sends their attorneys after you, and you have to pay for the government's attorneys. It's not the private guys that protect them that are the problem. It's when you're paying the government to come after you, because that's how it is. And so I just want to make sure that we're clear on that. Ramona Hage-Morrison was a little girl when all of this started, and I'll let her tell you the story, but suffice it to say that her parents fought this fight. She lost her mom during the fight, and years later her dad remarried a friend of mine, a friend of ours, Helen Chenoweth, and then we lost Wayne, and then we lost Helen. And so we've lost 3 champions already that have fought this fight, and now the kids are carrying on the battle, and Mark Pollitt, who is their attorney, carries on the battle. So we've got some champions in this room fighting for our liberty, and Ramona is one of the best. She's a consultant for private property rights. You won't find any better than Ramona Hage-Morrison.
Thank you, Elizabeth and Alan. Thank you for having me up here. And I just want to give a shout out to a few people in the audience. Mark, of course, who has stuck with us since 1991, through thick and thin, a lot of thin, and all of his family with him. I know it's a personal sacrifice as well, and but he has a few things marks on his belt from some of the accomplishments that he's made in this case. I also want to give a shout out to Matthew Keenan and his mother, Meg Keenan, Helen's daughter and grandson. And I have a few nephews in the room, Harrison and David back there from Tennessee. And I hear that none of them climbed on a roof while you guys were out doing your stuff today, so I'm glad to hear that. David. Thank you, Elizabeth. Thank you, Alan. I also want to give another shout out to my mother and my father and to my stepmother. Sorry, guys, you started it. They set the example for me and for my family for how you defend liberty, because so much of what we're doing is trying to do everything possible, all of us, to defend our rights, to defend liberty, to prevent what we saw in the Civil War. And so when I speak, it's in that term. We want to do everything possible politically, legally, in the public arena, and that's why all of you are here learning about liberty and the precepts of our founding in this government and this country. So let's start with that. I really admire all of you guys for making this effort. Our founding fathers shed their blood, sacrificed their lives, their family, their wealth, and truly lived out the words of Patrick Henry, where he remarked as Virginia was getting ready to fight in the war. He said, "Is life so dear, or peace so sweet, as to be purchased at the price of chains and slavery? Forbid it, Almighty God. I know not what course others may take, but for me, give me liberty or give me death." It is incumbent upon every generation. We didn't get this handed on a silver platter with no responsibility to take care of it and maintain it. But it is incumbent upon every generation to defend liberty anew. And that's how I see our battle. It's just part of that ongoing battle. My family didn't wind up on the beaches of Normandy or in the battlefields of Vietnam. But nonetheless, all of what we are doing is part of that battle, and that's where we must go. I am going to be focusing not on revising or repealing bad laws tonight, but on the unchecked power and abuse of power by employees of the federal government and sometimes the state government. And I don't mean everybody, but we do have a culture of abuse of power. We complain about the laws and even the courts, but really, it is how those laws are implemented by low-level, often lowly paid, federal employees that most endangers our freedoms and our liberty. I believe in our political activism, we often miss the mark when we focus on the laws instead of how those laws are implemented and how those laws are actually abused and how bureaucrats exceed their authority as granted by Congress or the state legislatures. When you look at how many people are running our government, that's a lot of people to abuse power. Not everybody does it, and God knows we need good employees, public employees. I don't want to make a knock against all public employees. But as a result of unchecked power and unregulated power of the federal bureaucracy, frankly, in my opinion, that is a bigger nemesis than all the bad politicians in Washington, D.C. James Madison warned us when he said, "I believe there are more instances of the abridgment of the freedom of people by gradual and silent encroachments of those in power, the bureaucrats, than by violent and sudden usurpations." As Elizabeth highlighted, my story began when I was a freshman in high school, about all of your age. Back in 1978, during the presidency of Jimmy Carter. My parents left California and bought a ranch, Pine Creek Ranch in central Nevada, a medium-sized Nevada ranch, believe it or not, about the size of Rhode Island. In Nevada, as in many western states, the vast majority of the state's land, as in Idaho, is administered by the BLM and U.S. Forest Service, and in some cases, the U.S. Park Service. Our ranch is a typical western ranch wherein there's a mix of private property, patented land, but also rangeland, something we call rangelands or grazing allotments. Now I'm going to tell you something that many of you may not be aware of. Grazing allotments, federally administered, federally designated grazing allotments cover much of the western public lands. Okay, so when I talk about our case, it impacts virtually all of those public lands. The rangelands are typically located on what we call public land. But when we bought Pine Creek Ranch, we bought the private land, but we also bought the ranch's historical rights established in the 1860s to almost all of the water, most of the roads, rights-of-ways, fences, and other improvements located on those public lands. Those split estate property interests are protected by the Fifth Amendment of the U.S. Constitution and the state's Constitution, making it unlawful for the federal government to take property without just compensation and, as important, in my opinion, due process of law. During that first year, before we had even had time to get to know our neighbors, before we had really gotten to know the range people that we worked with in the BLM and Forest Service, the U.S. Forest Service set out on a campaign to harass my family and economically destroy our ranching operation. Over the next many years, they did things like give us last-minute notices to move cattle from one area to another area, usually about 5 days, if not less. All of that we did horseback. They sent us trespass notices for cattle after employees of the government had left open gates to set us up for trespass. They made numerous impossible demands on maintaining stubble height, telling cows how far down they can graze cattle. So, 4 inches, 3 inches, cows are good at that. They've got a ruler in their head. They transplanted non-indigenous elk onto our allotments and water without our input or permission. Then, when the elk, as they are prone to do, started to tear out fences and so forth, the U.S. Forest Service demanded that we repair them immediately at our own cost. At one point, the U.S. Forest Service cited us for a fence repair on Table Mountain. My father sent a man on a full day's ride up to the top of Table Mountain, about 20 miles, and when he got up there, he found the flag referenced in the citation, and the flag was to repair replace one staple in one fence post on a fence. In one 105-day grazing season during the let's put this in context, during the presidency of President Reagan. Dad had friends high in the President's Council on Economic Advisors. He had a lot of friends in that administration. It didn't matter. The U.S. Forest Service sent us over 40 citations, such as the one I just mentioned about a stable repair. And then they drove 60 miles from Tonopah over 70 times in one summer to deliver 70 citations to my family at the front door, usually with an armed official. In the meantime, they publicly slandered my parents with our congressional delegation. We couldn't get any help from them, even though they were our friends in some respects. Elected officials in the state and in the ranching industry, accusing us of overgrazing, being uncooperative, and generally bad ranchers. Between 1978 and 1991, my father won 3 administrative appeals, doing everything he was supposed to do, going through the process. And each one of those appeals cost him between $50,000 to $150,000 to defend. But the harassment only escalated. It never changed the conduct of the federal agencies. In 1991, the whole thing came to a head when the government did a raid on our ranch, very similar to the raid that you saw at the Bundy Ranch, only with a few less bureaucrats, but fully armed, flak jackets, semi-automatic weapons, to confiscate 100 head of cattle, 104 head of cattle, which they kept, turned around and sold, and kept the proceeds of that sale. My mother and father decided they better liquidate the rest of the 2,000 head of cattle to prevent the government from stealing any more. I think that's what you call basically an asset forfeiture. And my father and mother never had a day in court, never had any of the tenets of due process of law before that happened. A rapist and a murderer got more due process than they did. In 1991, my father was lucky enough to get in touch with Mark Pollitt, who had been a former DOJ attorney in the Reagan Justice Department, and he had wrote the executive order on constitutional Fifth Amendment taking, so Dad figured that was a good place to start. And Mark, to his credit, most of the attorneys and judges that Dad talked to, or anybody in the legal field that Dad talked to at that time, told him he was nuts, to defend those split estate rights in a takings case. A lot of people didn't believe we owned them. And Mark, to his credit, decided they'd go make some law in the courts. So he's stuck with us through all this. 4 months later, after Mom and Dad filed the Fifth Amendment constitutional takings case with Mark in the U.S. Court of Federal Claims, the Department of Justice apparently didn't like that case because they retaliated with a criminal indictment of my father for cutting pinyon and juniper, trees that the federal government considers trash species of trees, out of the middle of our right-of-way, our irrigation ditch that we owned, with hand tools. He was convicted at the trial court level for criminal destruction of property valued at less than $100. And that case was completely overturned at the Ninth Circuit. But that didn't stop my father from having to pee in a cup and have a parole officer like a common criminal. Hage v. U.S., the case that Dad and Mark filed, meandered through the courts over a number of years. It had 2 separate trials, numerous published decisions, which any of those in the legal field know that's unusual. And then finally, in 2008, the court awarded my family a judgment totaling over $14 million with interest, and then attorney's fees over the top. Now, of course, the government appealed that case, and we appealed it up to the Supreme Court. But at the Fed Circuit level, the court reversed and remanded the case in part over a narrow or small part of the property. But the new Obama-appointed judge on the case at the trial court, when it was remanded back to bring that case into alignment with the Fed Circuit decision, instead of doing that, dismissed the case altogether. I think Mark would say a very unusual move by a judge. That is still in the trial court level, and it'll probably be appealed back up. So we're getting familiar with the courts in Washington, D.C., let me tell you. During this time, as Elizabeth mentioned, my mother passed away in 1996 as a result of a lot of the stress in part. My father in 2006, and Helen shortly thereafter. My mother never wanted us to stop the fight. She was hoping to prevent other families and their children from having to go through what we had gone through. I would also mention that when Dad married Helen, Helen stepped in there swinging right with Dad, and then some. She was a huge blessing to my family. While this case has been ongoing, and after the important rulings of Judge Smith, my dad and my brother, who were running the ranch on a shoestring, trying to keep all the cattle on the private patented land, and run it that way, they were basically about out of money, and it was becoming unaffordable. In about 2002, they had all these court decisions from the federal court saying that we owned all these property rights out there on those public lands, especially including the vested water rights, the forage rights, and so forth. And so what they determined to do, and they had applied, I might add, for another grazing permit. Of course, the government refused to grant them a grazing permit. So they decided they had to test this in the courts. And so they decided to stand on those court decisions and turn cattle out anyway. Now, some of you followed the Bundy case. Our case is very similar to that in some respects. We knew that they were going to come after us, either civilly or criminally. And finally, after my dad passed away in 2007, a year after, the government filed a civil trespass case against my brother and the estate. And my brother brought Mark in on the case, and the two of them, my brother pro se for himself, and Mark representing the estate, litigated that case. It finally went to trial in 2012. My brother, as I said, represented himself because we couldn't afford an attorney. And it was kind of funny. It was Mark and my brother, no attorney himself, and I was their paralegal because I was cheap, and it was about all we could afford. Anyway, they were up against a cadre of 5 attorneys at various times, plus numerous administrative staff in that courtroom, and those two ran circles around the DOJ attorneys. That trial went on for a month, over a period of from March to June of 2012. I had a little bit of fun there. In preparation for trial, we scanned 30 of 50 file boxes from the other case, from the takings case. We had to have it to get prepared for this case, and it gave me great personal joy to send over 57,000 pages of production documents back to the government. You have to get your thrill somewhere. This time we buried the government in paper. In addition, we had produced over 1,300 exhibits, 500 of which were title exhibits, documents documenting our property rights. Those documents were central to proving to the court that we had rights dating back to the 1860s that were protected by every land law passed by Congress. Now, this background is necessary to understand the extraordinary events that happened in the forage right trial. It was a real David and Goliath battle. Let me give you the ruling of the judge from that case. First of all, he put us under permanent injunctive relief in this court, very similar to the civil rights busing cases, because he said that he couldn't trust the discretion of the government. He ordered us to apply for grazing permits, and he ordered the government to grant us grazing permits. He restored the livestock numbers in those grazing permits to their original numbers. What the federal government has been doing across the board in any state in the West where there is government managed grazing permits is they have been cutting livestock numbers to just about nothing. And I will tell you, in the West, as you probably are well aware here in Idaho, instead of harvesting timber, we burn forests. Instead of grazing cattle and sheep, we burn rangelands. He recognized a half-mile forage right around each and every one of our waters and adjacent to them on either side. He recognized in an adjudication all of our vested water rights. He said the government could no longer cut our livestock numbers except in extraordinary measures such as a severe drought, and then never permanently. This is huge for the Western ranching industry if this is upheld at the Ninth Circuit. Then he went on, and he said that the government had engaged in a conspiracy to drive my family out of business and to deprive them of their vested water rights and their grazing preferences, beginning in the 1970s. He found evidence of racketeering, or RICO. He said the court and the conduct of the federal agencies was shocking to the conscience of the court, a finding necessary for a Bivens complaint. He found evidence of fraud, wire fraud, mail fraud. He used the word prevaricating, not in this part of the trial, so many, and various other words for lying that we all had to pull our dictionaries out. I'm joking. I've never heard so many words for lying in reference to some of the things that the government witnesses were saying. He held a BLM manager and a Forest Service ranger in contempt of court and ordered them to pay back the damages to my brother out of their own pocketbook. Now this case is on appeal up to the Ninth Circuit. We expect to hear, we're not sure when that'll be scheduled, but we expect to hear sometime in the near future. Here is the point. We've had numerous presidents over these federal agencies. They have managed to carry on a vendetta beginning in 1978 for 37 years. They have come up with new attorneys to replace old ones. They have just kept after it and papered us basically in the courts. I don't think they ever expected us to stick around this long, and it certainly helps to have another generation to carry on the fight. My brother, to his credit, has done carried an enormous load throughout this situation, and I thank him for it. But the point of this is no president has ever been able to rein in their own bureaucracy, even ones that might be sympathetic to our cause. And that is true throughout the federal agencies. And I think one thing would go a long ways to changing the culture of the agencies, because so many, in certain instances I should say, the conduct of the federal agencies is outside the scope of the law. There is criminal activity going on in these federal agencies, not by all federal employees, but there is a lot of it going on where they're completely outside the laws under which they govern, under which they get their authority. When they operate outside those laws, they don't have authority to do that. But if you sue them, and we could sue them given the findings of the court in our case, but the legal counsels have not been all that encouraging about the success of that. The reason is, in part, is federal employees have immunity. And one thing could, I think, change the culture of the federal agencies dramatically, and that is to eliminate their their immunity from prosecution if there is criminal intent or a high level of a high bar to charge them, not just for frivolous stuff. Do you think that would affect the way that Lois Lerner conducted herself in front of the Congress when they were investigating the IRS if she was just slightly concerned that she could be prosecuted? Now she can be prosecuted sort of, but not in a serious way, I don't think. Or the head of the VA, or the head of the GSA, or any of these other agencies that have been in Hillary Clinton. They better check the Hudson for her drive server. But anyway, that one thing I think would go a long ways in changing the culture of the agencies. You would not have to prosecute that many federal employees to absolutely change the way they do business. But I'm telling you, some of those guys need to wind up in jail. And again, we look at, I've worked in public policy and so forth, and you look at ways to fix things. To change the Endangered Species Act would take a miracle, a perfect lineup of the Congress, the Senate, and the presidency. It's very hard to reform laws, but it may not be as hard to reform the bureaucracy. The bureaucracy in this country is a huge part of our problem. Thank you very much. And Elizabeth, you said did you want to take questions?
Are there any questions for Ramona?
How did she survive?
She wants to know how you've managed to survive, your family.
God.
Short and sweet.
A lot of miracles along the way. Yeah.
Is your brother still involved in?
Yes. In fact, he was up here speaking for the Idaho Freedom Foundation last year.
Yes, I heard.
And he's running the ranch. And yeah, I'm very proud of him. He's my baby brother.
And
So I
we
can say
should-
that.
We should probably mention that it's Judge Jones. I think when a judge does the right thing, his name should go out and people should recognize him, and he did a fine job for you, I think.
Absolutely.
He did the right thing.
He did the right thing. I also would like Mark to tell a quick story. How would you like to tell the story about your intimidation of the other council?
Oh, there you
Well,
go.
I don't intimidate people. Would be wrong, that is for sure. First of all, I have to say about Judge Jones, he was very careful at drafting his decision. When it came out, it was 103 pages long. He went through that court record and the trial record in great and loving detail, so there could be no real question as to the facts he found. It was a very lengthy trial. He got a little impatient from time to time, but toward the end, when all of our evidence started coming in, he literally apologized to us for being so impatient, which makes him a remarkable federal judge, all by its lonesome. But you talk about intimidation. What it really was, well, I'll give there are lots of examples, but I'll give you just one or two. One of which was, as Ramona said, Wayne was acting as his own counsel, and I was working with him to, kind of give him a little education on, examination, cross-examination, the rules of evidence, and all of those things. And so, as he was representing himself, he could choose to examine witnesses. If it was a government witness, he could cross-examine. If it was one of our witnesses, he could do direct exam. And sometimes he did, and sometimes he did not. And at one point, during the trial, as he was, we were going through one of the witnesses. It was one of our witnesses, so I did a direct, and Wayne didn't do a direct. Government did a cross-exam. I got up and did a redirect. Government was getting up to do a recross, and Wayne decided he was going to do a little redirect examination of his own. So Wayne, pops up and he comes up to the podium, and while he's standing at the podium, the government attorney, a guy named Bruce Traubin, is scooping all of his papers up like lawyers like to do. And he's scooping up, and he turns toward the podium and starts to walk toward the podium, and here's Wayne standing at the podium, and he goes, am I being tag-teamed? And Judge Jones very patiently explains, Mr. Hage is representing himself. He has the right to ask questions on his own behalf. And then he looks at Ramona and Wayne and I over at our table, and he goes, I see two attorneys over here. He looks over at counsel table for the government. He goes, I see 7 attorneys over here. Tag team? And then he leans down to the court reporter and says, I want that laugh reflected in the record. And toward the end, and here's the thing, and it's kind of important to the understanding of the whole case. As Ramona said, they had gone after Wayne Sr. 4 months after we filed the takings claim in the claims court, clearly trying to intimidate him, to use up his resources and hoping to get a decision out of the district court in Las Vegas before the claims court could rule on the substance, thinking that that could derail the takings case, not understanding that actually had they won that case, ultimately it would have strengthened the taking case. If you can take perfectly lawful behavior and turn it into unlawful behavior, I can't think of a better way to define a taking of private property. So they, as Ramona said, they decided they were going to try this against the Hage family again, and my best sources tell me that they literally held a meeting to decide whether Wayne the younger was going to be as much of a pain in the posterior as Wayne the elder, and unfortunately for them had concluded that he wasn't going to be as much, and it was a big surprise to them when we counterclaimed. Basically, and I did not use the word conspiracy, I want you to know, I very carefully talked about a pattern and practice of conduct. I didn't spend all that money in law school for nothing. And I let the judge kind of fill in the blank, and he ultimately did. As Ramona told you, he determined that there was an actual and intentional conspiracy to deprive the Hages of their private property rights, their constitutional rights, and to interfere with their lawful business activities. But one of our counterclaims was due process, and the government attorney who was assigned to that particular argument, they threw a lot of straw men out, which hoping that we would take the time and that we were allotting to our argument to knock them down, and we just kind of ignored them. But when Bruce gets up, he stands there and he goes, well, but I don't understand this due process claim. I don't understand it. Now, I believe that he did not. And I believe that he did not because the agencies have gotten away with this stuff for so long. Sometimes it's because of a lack of education, and that's one of the reasons I bring this up, because we're hoping to educate a new generation in the principles of liberty and the understanding of the issues, because a lot of these cases were decided by people who mostly did other stuff. You know, they were what I call was the light red, was the light green lawyers. In other words, who ran the damn stoplight out there, or they were contract lawyers. The Hage family attorney himself was relieved to have me come in because he was representing the estate. He couldn't represent himself. And Jack is a fine lawyer, but he does trust in estates, and he knows that. So he wanted to have somebody who does this. And a lot of these early cases were done by people who picked the wrong issues or made the wrong arguments. No fault of their own. There just weren't many people who do, you know, what I do out there. And that's no good reflection on me. It's just a poor reflection on the education in constitutional government that you get in law schools. You heard something about that last night. They teach constitutional law and treat it like any other law instead of what it really is, constitutional government, which should not be subject to the normal, let me see how I can make this look as opposed to what it is. And so when he gets up there and announces that he doesn't understand this at all, I believe him. He's bewildered. But then he says something that any sympathy I had for him evaporated because it was just plain funny. He says, "Am I stupid?" And I can guarantee you at least half of the people in that courtroom are going, yeah, absolutely. We don't know how you could not get this. It is on appeal. They are feeling somewhat intimidated, and this, I can tell you part of this shows up in their appeal. Their two arguments were, well, he's just plain wrong. I don't know how he could possibly have come to that conclusion. And that's both on the appeal in the main case and the appeal in the contempt out there. Their other argument was, he just didn't like us. He's being mean. He's prejudiced against us. Now, courts of appeals don't really like those kind of arguments. They like to decide the cases on the actual merits. And so they're not real keen on, he's just so mean. And they did. They whined and moaned and complained about that like, you know, hungry teenagers. No offense meant. Well, maybe a little offense. But the thing was, they don't get it. And they don't get it because they have won so much without really even trying. Most of the cases are decided on summary judgment motions or motions to dismiss. This one went to trial. And it went to trial with evidence that just piled up and piled up and piled up and piled up so that it could not be ignored. There are some things that shortcuts are not meant for. As the character says in Lord of the Rings, shortcuts make for long delays. And so it is also an illustration of another point. And the other point is that, as Ramona and just about everyone else has said here, there's no sweeping, exultant victory like you see on television or in the movies. We got into this mess gradually. We're going to get out of this mess gradually. The trespass case, I was fortunate because that was the next step I had contemplated in this battle. I just didn't know that I was going to be fighting it with the same army as we fought in the takings case. So it is a sign of good hope. It can be done. It can be done despite what they say. You can fight City Hall, and you don't have to have a big team of lawyers and professionals as they had to do it. What you have to have is spirit, willingness, toughness, education, training, and that one indispensable thing that everyone needs, experience. For every good thing you do, you will make some messes, but eventually you will take 3 steps forward for every 2 back. That's how we won this one. That's part of why it took so long. And that's how we will win every battle from this way forward, or at least the war. We won't win every battle. The important thing is not to let that discourage you, because that is the plan. That is the hope. If we just overwhelm them with money and lawyers and documents and motions and tisking, and aren't they bad people? They're just not compassionate for our judgment. That's how they hope to wear you down. My hope is that people here will not be worn down, that they will fight individually, and most importantly, that we'll stick together. Because one thing the other side has got for us, they put their minor differences aside and they focus on the things that they can all agree on, and they stay together. And unfortunately, on our side, we often come together for the crisis, and when the crisis is over, we're off back doing things that we would like to do, and that is both our strength and our weakness. Yeah. So that's both our strength and our weakness. So it's what makes us wonderful, but it is also what makes us vulnerable. And we can fight that with honor. Any questions?